seated. Thank you. It's wonderful to see all these smiling faces. Don't look so grim. We understand the subject matter is a matter of concern to everyone here, but let's address it and do it civilly. Thank you very much. Just for the record, the case up for this morning is Planned Parenthood versus South Carolina et al. Ms. Murray, are you prepared to report, ma'am?
I am.
You may proceed.
Good morning, Mr. Chief Justice, Your Honors. May it please the Court. I'm Julie Murray. I represent Planned Parenthood South Atlantic and Dr. Catherine Ferris, but I'll be presenting argument this morning on behalf of all petitioners. I'd like to begin this morning by starting out with what Senate Bill 1 does and does not do, because the contours of the law are relevant to the constitutional interests at stake. Despite SB 1's title as the Fetal Heartbeat Protection Act, the act applies when a pregnancy is at its earliest embryonic stage, nearly a month before a point in pregnancy when doctors would actually say that it involves a fetus. And at that stage of pregnancy, there is no audible heartbeat. In fact, there is no heart at all. Rather, there are electrical impulses that are visible only on ultrasound.
So you're saying that some of the definitional section of the act before us is perhaps contrary to medical science in that it refers to a fetus when we perhaps should be talking about an embryo, and it refers to a heartbeat when in fact we're talking about electric flickering. Is that your argument?
That's correct, Your Honor. And that's spelled out both in our declarations from petitioners and also in the expert declarations of Dr. Eleanor Norton.
Ms. Murray, let me ask something. I apologize. You're going to get a lot of questions, and I don't think you're going to get to maintain the outline. But the Chief is always very good and kind about allowing lawyers to make the points that are not in response to specific questions. So I'm confident that you'll be able to fill in the gaps if the questions don't raise issues that you want to address. I have two areas that I want to cover on your side, and I'd like to try one of them now. It's a series of questions. One answer may be a little involved. The others are just short.
Okay.
You contend that the privacy provision, either in Article 1, Section 10 or a function of substantive due process, grants a privacy right that would extend to a right to abortion. And because there's this fundamental right, you believe where the state has drawn the line in the act, and we've read your fine briefs and for amici who've submitted briefs, you say that transcends the Constitution, violates the Constitution. So the line drawn by the legislature is constitutionally impermissible. Under your approach, we would remove that as a constitutional mandate, but we would have to substitute it with something else. So what do you believe the Constitution mandates in terms of a time factor?
Well, Your Honor, we don't think the court actually needs to address that question. So I guess the premise that you asked about is the court would have to substitute something else. And I would say the court does not have to do that. It has before it only a statute that bans abortion starting at 6 weeks of pregnancy. And so the only question the court needs to address is whether at that point the privacy interest of a woman in being free from months of physical, emotional impacts of pregnancy and later childbirth, some of which may be lifelong, is an unreasonable invasion of personal privacy. So at that point, we think the
we just stop.
I think you stop.
And,
that is the
and
most
then
limited
what's the
approach.
law? The retention of the codification of Roe? What's left? Where's the line?
Well, as you say, there is a codification of Roe in the state which already bans abortion in the third trimester in most cases. There's also a 22-week ban in place in this state that is not challenged by petitioners. And I would note, of course, that petitioners do not, under the terms of their state licenses, provide abortion beyond 14 weeks anyway.
Ms. Murray, not to interrupt, but just to piggyback on Justice Kittredge's question, why wouldn't we be sort of channeling Chief Justice Roberts' opinion in Dobbs, which was, as I understand it, he would have upheld the 15-week ban that was before the court. In other words, why would we go any further? And I think that's what Justice Kittredge is asking, should we go further? And you seem to be saying no, but then you're bringing in all these other time periods.
Well, the other side, Your Honor, has suggested that we have not provided a stopping point for our position. So we did, in our reply brief, talk about the other states that have found consistent with this state's distinctions between pre-viability and post-viability abortions. We did talk about that as a stopping point. But as Your Honor suggests, that doesn't have to be the stopping point, and the stopping point could conceivably be earlier if this court were presented with a case like the one that Justice Roberts addressed, a 15-week ban. And you're correct that Justice Roberts, in saying that he would have upheld a 15-week ban, referred to 6-week bans as a comparison of how early they are. And so South Carolina's ban, as I understand Justice Roberts' opinion, or just his opinion in Dobbs, that recognized that 6 weeks in a pregnancy is extremely early, and as the record here demonstrates, it is before most women who have abortions even know they are pregnant.
How do you determine where the line should be drawn is the question Justice Kittredge was actually asking.
If we find it unconstitutional, where are we? Where is the line?
Well, I think this court, for example, in Whitner and the follow-on in the McKnight case, did distinguish between the strength of the government's interests before viability and after viability. So before viability, although it recognized that the state may have an interest, even a profound one, in protecting potential life throughout pregnancy, that interest becomes compelling at the point of viability. So that is one line that I think is already...
But isn't viability a sliding scale as medical advances are made?
Well, it is not a sliding scale. Viability varies by pregnancy, but it is a medically understood term. If you talk to a doctor about the point of viability, doctors who deal with women who are pregnant know how to determine viability. In terms of the 6-week ban, however, that is essentially this idea that the point at which you can see cardiac activity in an embryo at 6 weeks is somehow medically relevant.
It seems to me like you're just really wandering intentionally away from Justice Kittredge's question, if he doesn't mind. If the 6-week ban is struck down, we're left with the 2016 Act.
If the 6-week ban is struck down, this state's prohibition on third trimester abortions and abortions after 22 weeks of pregnancy would remain in place.
Thank you.
Well, let me ask you this, Mr. Murray. You brought the point, or at least the focus I was attention on your reply brief. In your reply brief, you make a point of saying the relevant question is not whether the Constitution refers to abortion, but whether the privacy language applies to laws infringing on bodily integrity and decisional autonomy. We just talk about that a little bit for me. Explain that.
Sure. So as we have argued, the language of Article 1, Section 10 is broad in the sense that it talks generally about unreasonable invasions of personal privacy. In Singleton, for example, this court didn't ask whether the West Committee or legislators would have thought about or did think about forced medication of inmates. Nevertheless, the court held that forced medication of inmates generally was an unreasonable invasion of privacy unless it was necessary to protect the health and safety of the inmate or other people, and even then, only if it was in the best interest of the inmate himself. So I think what this court's decision in Singleton teaches us is that the question is not whether each particular application of privacy was something that the committee considered or even thought about, but rather whether within the broad policy statement, which is what the West Committee itself called the privacy provision in its report to the General Assembly, whether within that broad statement of policy, the right to bodily integrity, including the right to decide whether to remain pregnant, can be encompassed. And we think it clearly can be, contrary to the state's position, which would place limitations on that language that simply aren't there.
Should this court be overly influenced by the West Committee's decision?
No, Your Honor, but I think it's certainly...
For that matter?
I think first and foremost, the court should start with the text. And the text of the Constitution gives a broad right against unreasonable invasions of personal privacy.
Who makes the final decision about the constitutional amendment? The West Commission or the legislature, or is it the public when they vote at a referendum?
Well, I think in this court's case law, when you have examined the meaning of constitutional amendments that have gone to the voters, you've said that both the understanding of the legislature and understanding of voters as to what these provisions would have meant would be relevant to that.
All right. If that's relevant, what did the ballot page say? You know, when we go into the voting booth, they have this long paragraph, and there's a heading over the question. What was the heading?
So that
it was search and seizure, right?
Not the heading, Your Honor. So the ballot included, and this is at page 874 of the joint appendix, the ballot included the full text of Article 1. So that voters voted on Article 1 as a whole, not the Section 10. And then that included a summary of what Article 1 did, which is, Your Honors know, there are a lot of rights in Article 1.
Well, what did the ballot question refer to? Did it just say right to privacy, or was there any type of overall explanation of what it was about? You said it was page 875?
Page 874 of the joint appendix. So that would be...
Volume 5, maybe?
So this is the legislative resolution that said what voters did. And it says there on Section 2 that voters will be provided the full text of the article in addition to the following words printed or written thereon. They vote in favor or against.
What page is the actual ballot question on?
We do not have a copy of the ballot itself in the joint appendix.
All right, you mentioned something about the final report of the West Commission. You said it was a broad, designed to be a broad statement on policy.
Correct.
To me, that is completely and utterly out of context, because the sentences before that say only things about the historic provision on searches and seizures is retained. In addition, the committee recommends the citizen be given constitutional protections from an unreasonable invasion of privacy. This additional statement is designed to protect the citizen from improper use of electronic devices, computer data banks, etc. Since it is almost impossible to describe all of the devices which exist or which may be perfected in the future, the committee recommends only a broad statement on policy. So tell me how you jump from that box to what you're talking about today.
Well, to be clear, Your Honor, the West Committee report we have discussed in our papers because it is the core of the state's position as to how you would limit the right to privacy on its text. So assuming that Your Honors get past the text of the constitutional provision, you get past Singleton, which is inconsistent with the way that the state is attempting to interpret Section 10, and you start to look at history. To the extent that you are looking at the West Committee report, I think the statement to legislators also has to be taken in the context of proceedings in which the West Committee had before it clear.
But you will agree that it should not be taken out of context.
I would agree that it should not be taken out of context.
In the context was that the West Committee proposed a standalone, independent sentence. The legislature rejected it, lifted that independent sentence, and added it as a clause to the existing search and seizure provision. Why isn't that context some meaning? I understand we cherry pick what everyone recognizes are general words. We cherry pick some general words and lift them from a paragraph or a division, and they take on a whole new meaning. But it seems they have to be somehow tethered or linked back into the original context.
So I will say this, Your Honor. As I understand your question, you're asking whether either the warrant clause or the search and seizure language is somehow a limitation on the right to privacy. To the extent that the court wanted to hold that, it would not only have to overrule Singleton, which did not in any way hinge on a search or a seizure or something where a warrant would have issued. But in Forrester, for example, in Counts, this court first looked to whether there was an unreasonable search or seizure. And even if it found that there was not, it still went on to look at the right to privacy. So the limitation that you're suggesting in the language and that the state has suggested, I would say, number one, would make a hash of this court's existing case law.
That may be a fair point. And also, the construction of the privacy provision urged by respondents has not been previously urged by the state in Singleton, Forrester, Counts, Dykes, etc.
Yes, Your Honor. And I would say as well, there are 6 other states that have express privacy provisions like South Carolina. So the Alaska, Minnesota, Florida, California, Montana, and Washington all have express privacy provisions. And in each one of those states, the highest state court of those states has held that their right to privacy covers bodily integrity. And not just bodily integrity, it covers the decision whether to remain pregnant or to have a child. Certainly that's not binding on this court, but I do think in terms of thinking about how to interpret what people would have understood privacy to mean in the late 60s, early 70s when many of these states adopted their provisions, it's certainly relevant that other state courts have looked at very similar language and come to the conclusion that it covers the right of a woman to decide whether to bear a child.
What's the limiting principle? There has to be a limiting principle. We can't, as Justice James alluded to, look at the word outside the context of Article 1, Section 10 and just treat it as some amorphous right that is not constrained by some objective legal framework. What is that framework?
So I think that what I would say is I think that there is both a historical sort of understanding of privacy that was in place at the time this amendment was adopted. And so as we lay out in our reply brief, both from dictionaries of the time, legal definitions of privacy, case law, this court had recognized tortious invasion of privacy. All of those background understandings of the word privacy and interpretations of privacy in the law.
I don't see how the history helps advance your cause. Abortion was nowhere on the radar when this was discussed, yet in your brief you point out it was everywhere in society and it was in newspapers, and South Carolina was amending the abortion statute, so it was on the public radar, but it's nowhere to be found in the origins of this provision. It seems to me your best argument is this court has held that the provision is broad.
That is correct, Your Honor.
To say it's broad is one thing. That breadth must have a limiting principle, and I'm trying to understand from your perspective, what is that limiting principle? Privacy, everyone loves privacy in the abstract, but our society, in various state legislatures, local governments, pass laws and ordinances regularly that affect privacy interest. And I just wonder if we stretch this concept of privacy, where are we on laws that we accept are valid regarding prostitution, bigamy, polygamy, assisted suicide? Where do we draw the line?
So I have a couple of responses to that. I think the framework is either strict scrutiny, which we have urged, or some other form of heightened scrutiny if that is what the court would put in place. We would say strict scrutiny. That's consistent with what the majority of other states that have examined their express privacy provisions have applied to those. I would also say, just as a matter of principle, in Singleton, this court recognized that an inmate convicted after a criminal trial and sentenced to death had a personal privacy interest in not being forcibly medicated against his best interest. Surely, if the state of South Carolina provides and protects that privacy interest of Singleton, it would extend the same privacy interest to women who are pregnant at 6 weeks and are facing potentially months-long or lifelong physical and emotional impacts on their bodies. So I think the line drawing in part will come from the framework that you apply. And I think even if the court applies strict scrutiny, we were curious, for example, about how do states deal with suggestions of drug use in the home? Is that a privacy interest? Even states like Florida, California, I believe Minnesota was one. They've rejected those arguments as having a privacy interest either at stake or in the application of strict scrutiny. They have sustained restrictions of the kind that you're describing.
Is part of that because the provision says unreasonable invasions of privacy?
Well, I think certainly the unreasonableness in the strict scrutiny context would come in when the government is describing its interests in the restriction. But I think it could also come in at the point of what is a personal privacy interest? Is it smoking marijuana at home, for example? I think other courts, even with the strict scrutiny standard, have said no, that's not a personal privacy interest. However,
Why not?
Well, I mean, it certainly would be a case far from this one, Your Honor.
No, but why not? Why isn't lighting up in your own home your business? And it is a privacy right.
Well,
maybe because marijuana was criminal, is a criminal offense.
I don't think that would be the distinction. What I would say, though, Your Honor, is that certainly if this court recognizes that a pregnant woman at 6 weeks pregnant in its earliest embryonic stages has a right to decide what is done with her body when she is facing potentially lifelong impacts from that pregnancy, that is easily distinguishable from what someone does in their home with drugs, for example. So I guess my point simply is that the court can apply strict scrutiny to this restriction and should hold that the invasion of privacy is unreasonable.
You spent 5 minutes finally getting down to the point. That's the limiting principle, is whether the restriction on the privacy right is reasonable.
Yes, and at bottom...
You keep talking like the privacy interest is some sort of absolute. And in other state constitutions, it is treated more, at least in terms of language, like an absolute. But here it's not. Here the privacy provision itself contemplates that there are going to be government intrusions on that privacy interest that are acceptable.
So,
right?
Yes, our position is not that the privacy interest is absolute, and I think even other states with express privacy provisions do not treat their provisions as absolute.
There's all this talk on both sides about you've been accused of not having a limiting principle, and frankly, you're not admitting that you do because you're contemplating where your next challenge will come in case you win this one. But the limiting principle is very clear. The government of South Carolina has the authority to restrict any privacy interest so long as doing so is reasonable.
And in this
Am I right?
The standard, yes, is whether the invasion of a cognizable privacy interest is unreasonable. And
it seems to me your best argument should be that this can't be reasonable since it comes at a time when most women or many women would not even know they were pregnant, let alone have enough time, if they thought they might be, to get an appointment with their OBGYN to confirm it. Isn't that a strong argument in your
Yes,
favor?
Your Honor. That is among many arguments that would support finding this unreasonable is the fact that most women who seek abortion do not even know they are pregnant at the time.
Well,
Go ahead. I'm
no,
sorry.
you go right ahead.
I'm saying, well, does it matter that the data you provide from DHEC shows in 2020, 44.5% of abortions were done at 6 weeks or earlier. In 2021, the figure is 47.9%, 6 weeks or earlier. Does that matter?
So the data that you're mentioning from DHEC, I believe defines the pregnancy 6 weeks by by post-fertilization. So it's actually what we have been talking about in this case, 6 weeks pregnant. The DHEC data would be 8 weeks.
That's at 2 weeks.
And those 2 weeks matter, right? I mean, in terms of early pregnancy, if you look at when people are able to get abortions and find out they're pregnant, get the money together, get the travel together, childcare, all of the impediments, those weeks are critical. We know nationally that more than 90% of abortions occur in the first trimester of pregnancy, but 6 weeks is incredibly early.
What is the data then on how many women don't know they're pregnant before this particular threshold in the South Carolina law takes effect?
And may I add to that, don't know does not equate to when you have an abortion necessarily. I think
That's correct. South Carolina, there are many impediments to getting an abortion, even when you realize
what's your
you're
answer to
pregnant.
Justice Few's question? Where
My
is the
answer
data?
to your question is paragraph 31 of Dr. Norton's declaration,
In which he says many.
in which she says the vast majority of women who have abortions do not know that they are pregnant by the time that she says cardiac activity is detectable. That is the evidence in the record in Dr. Norton's declaration.
I might be looking at the wrong page 166 of the appendix, paragraph 31. Many patients do not learn they are pregnant before 6 weeks.
Yes, that is
Where are the
in, I
words
believe,
vast majority?
that is in Dr. Ferris's declaration that you're looking at. If you look at Joint Appendix page 536, which is in volume 3,
Page 536, volume 3, okay.
While we're contemplating that, you have other grounds that I'd like you to explore in the void one in particular.
the void ab initio. Yes, that's correct. If your honors, are okay with
Why
me.
would you even make that argument?
Well, Your Honor, because the statute was patently unlawful under federal law at the time that it was adopted. And in this court's case law.
If we were to say it was void ab initio, they would just reenact it after Dobbs. So I just don't see how that advances your ball down the field.
It delays it.
Yeah, it just delays it. I mean, why would you? I don't get that argument.
So, Your Honor, we think that it is a prevailing
But it was your
argument.
last argument, so
To be clear, I am not arguing that you should do that, but it is a ground on which you could invalidate SB1 should you so choose. I will say, though.
Does that matter?
I'm sorry?
Finish your thought. I apologize.
Well, I think, unlike cases, for example, where you would decide issues on statutory grounds as opposed to constitutional grounds, there are constitutional implications in both of those claims. And in addition, I think Justice Hearn is absolutely correct. The efficacy of deciding this case on void ab initio grounds, if there is another way to invalidate SB1, is minimal, if not non-existent.
I am very
You may be
concerned,
back.
and I don't mean to short circuit the Chief Justice's question.
No,
and I want to make
I want to
sure.
make sure that we got to all the grounds. And I'll start
Yeah,
with the
I
bottom.
am very concerned about the provision that requires if a woman is seeking an abortion based on rape or incest, that
The equal protection.
that the equal protection. I was a family court judge for almost a decade, and I'm very well aware that many families have secrets that they keep until they're in their grave. We may disagree on whether they should keep certain things secret, but one of them is perhaps who the father of a child may actually be. And I'm concerned that this act violates a woman's right to keep that a secret.
Yes. In the state of South Carolina, if you are a victim of sexual assault, an adult woman who's a victim of sexual assault, it is generally up to you as to whether to report that assault. That's true if you go in for miscarriage care. If you go into your general practitioner, you have that choice. SB 1, so far as we can tell, imposes the only reporting requirement that actually conditions the availability of health care to women, and it selects only one kind of health care, abortion. If a woman comes into a Planned Parenthood for an abortion, is told about the reporting requirement and says, I can't do that, I'm not ready, and she leaves, the doctor who talked to her, the nurse who talked, they have no obligation whatsoever to report. This is a requirement that is essentially imposing obligations for reporting in a transparent way to intimidate women who seek abortions. And certainly, we think even under a rational basis review, that distinction.
But on the other side of that, if you assume that the doctor is put under a statutory requirement to report all indications coming from a potential abortion patient that they've been raped, would that change it?
If the doctor would have to report,
even if the woman chooses not to have an abortion?
Well, that would certainly be a different law. I think that at that point, I would still question how they could single out one kind of care. I'm not aware of any other reporting requirement.
They're singling out women who have been raped because that's not the only people who get raped, but that's a very high, if not vast, majority of rape victims are women.
That's Mr. Chief Justice, may I answer?
We're going to be here a while.
Yeah. We gave you the time limits to focus your arguments, so we wouldn't be here while he's talking about, but we do understand we will be here for a while.
Okay.
And by the way, I have that phrase, vast majority, in my mind because I want to go back to your use of it a few minutes ago. But thinking back on the point that you were just making, doesn't the state have a valid interest in prosecuting people who rape women?
May I answer?
Please, you have time.
So,
until I tell you your time is up.
Okay. Your Honor, as we say in our brief, this requirement is also not tailored to a prosecutorial investment.
Sure, it has in the abstract. Then we will get out of here more quickly.
In the abstract, yes, Your Honor. The state has an interest in prosecuting. In other situations, the state has imposed reporting requirements on physicians who see evidence of violent crime, isn't that right? They have imposed reporting for child abuse, which of course our clients comply with. Mm-hmm. And the reporting for people who come in, for example, with gunshots applies whether or not those people get care. It is a mandatory reporting. My question here is not designed back at your original point, but does the state have, and obviously it does, a valid interest, a compelling interest in discovering the occurrence of rape crimes and the identity of the people who commit them? I would not say that is a compelling interest, which is the most rare among government interests. And in any event, this is not at all rationally related to that interest.
Well, I have other questions. Yeah, I've got. Don't sit down just yet.
I want to go back to this limiting principle, and I don't mean to keep harping on it, but I want to understand, because it's important to me to know that this privacy provision taken out of Article 1, Section 10, if it's broad, there has to be some objective legal framework that allows us to measure challenges to legislative enactments. And what I'm afraid we're getting close to is you want a formulation of a standard that puts everything on the five of us, and we in turn start making policy decisions. And that's a line that I have never and will never cross. So what's the legal framework that makes this a legal question, a legal result, and not a policy-driven result?
I think the framework comes both from the established legal and ordinary understanding of privacy at the time of adoption. It comes from this court's case law that has consistently in other contexts distinguished between the state's interest post-viability and pre-viability. And it comes from
This court's case law on that?
Yeah, for example, the Whitner case, where this court recognized as compelling the interest after the point of viability, and important but not compelling before viability. So I think there is already case law on which this court could draw that distinction in the context of abortion.
But isn't that what Alito said in his Dobbs opinion, that was the problem with Casey as well as Roe, this setting forth a scheme, a plan, a policy decision as to when an abortion and viability was relevant? That's something that the court should not do. Isn't that what they said? That should be left to the states to do?
I think, Your Honor, we have supplied a framework. We suggest strict scrutiny, although I will say even if you did something akin to a balancing test, the undue burden standard under federal law for nearly 50 years was a form of balancing. And every state until Dobbs, every court to look at an outright ban on pre-viability abortion had held those unconstitutional under that balancing standard.
That's because they were bound by the Roe-Casey precedent and Webster, et cetera. It's not like they had flexibility to go to the states and have different formulations and different value judgments and different policy judgments. Dobbs puts us in a new era.
Well, Your Honor, I think, again, you could also rely on your decision in Singleton, which recognized that at some point there are certain bodily interests in what is done with one's body that are just off limits.
Unreasonable.
They are unreasonable per se.
And going back, I don't want to get you down the road again of the West Committee, because I think we all know that that's of limited help, although there are some things about the West Committee notes and what they had in front of them. Obviously, they had materials about Griswold, so they were aware of the right of privacy. They did consider a provision that would have specifically limited this privacy right to electronic surveillance. They rejected that. And we also have in our record the letter from then Attorney General Dan McLeod, who made it very clear that he was aware that the provision would impact health and public welfare, that it wasn't just limited to search and seizure. Isn't that correct?
That is correct, Your Honor. And I think it is important to point out that the position that the state has advanced in this case would make it so that some of the material that Attorney General McLeod pointed to, this consideration about the mining of electronic databases for health records, safety records, tax records, under the state's position, that would be irrelevant. It wouldn't be protected by the privacy provision altogether.
Ms. Murray, can this court rule in your favor without setting forth a framework for abortion, meaning with time limitations, first trimester, second trimester, third trimester? Can this court rule in your favor without addressing those concerns?
I think it could do that, Your Honor, yes.
In fact, I think it should do that.
I think it is the most limited way to decide this case, is to decide that at 6 weeks of pregnancy, an invasion of women's privacy to their bodily autonomy is per se unreasonable.
That what you just said is I think your answer to Justice Kittredge's question, because if we look at the say the 20-week ban and say, that seems like a fair way of balancing out the state's interest in preserving unborn life and whatever other interests there are on the other side that derive from privacy or liberty or simply the interest that a woman has in choice. We think that 20-week ban is reasonable. Certainly that's what in 2016 the legislature decided. But then we move on up to the to this ban. And if one of us up here were to say, I don't agree with that. If I were in the legislature, I wouldn't have gone to 6 weeks. I would have stayed at 20 weeks. In other words, I think that 20 weeks is the line for reasonable limitations on the right of privacy or liberty that a woman has. But that is, at least in its first instance, our policy judgment. not our legal judgment. How do we distinguish between the policy judgment of where we think the line ought to be and the legal judgment of where the line can't be crossed? And it has to be what you said, per se, or in other words, for us to invalidate a certain line, 20 weeks, 6 weeks, whatever, we would have to find that it's basically unreasonable as a matter of law.
That is what we're seeking.
So in
yes.
other words, we would, and you could put all sorts of different ways of describing it on there, but we would have to say there's not a way that a rational decision-making body, such as the House or Senate of South Carolina, could decide that this was reasonable. Because if they did that, that is per se unreasonable.
Yes, this court applied a categorical rule in Singleton as to when forcible medication of inmates is permissible. We are asking for a categorical ruling that at 6 weeks of pregnancy, an outright ban on abortion is categorically unreasonable.
But you're not asking us to say when is a good time.
I am not. I am responding to the court's understandable questions about how to decide.
We deal with the law here. We don't make policy.
Yes. The question to your question, Justice Few, obviously the question before this court is not what it would have done had it been in the legislature.
All right,
it is what the law requires.
And that takes us back, I think, to a question that Justice Hearn got us started on a good while ago, which is I'll try to use her words, but it was something along the lines of how many women know that they are pregnant. One on page 545 of the record, where the words vast majority are in there, but this is your client saying that she disagrees with the statement, the vast majority of women have sufficient time to obtain an abortion prior to the point of a detectable heartbeat. That doesn't really answer my question of what is the data on how many women don't know that they're pregnant in time to meet this deadline that's under our current bill.
So we do not have specific data on that in the record, and I'm not aware of specific data on that at the 6 week marker. I would say, however, that our position, although certainly if you don't know that you're pregnant, you can't get an abortion by that point. But even people who do know
there's some women who don't know they're pregnant when they're 8 months pregnant, right?
Occasionally, yes.
Okay. So when you say occasionally, you're characterizing the number of people who meet that definition in a vague way that's hard for me to understand. Also, when your clients say many in their affidavits, that's characterizing the number of women who don't know they're pregnant at 6 weeks in a vague fashion that's hard for me to understand. If I'm going to use your suggestion that the number of women who don't know they're pregnant at this point in time is problematic in terms of the constitutionality of this statute, I need to be able to put some certainty on what that means, and you don't have it, right?
So I don't have the particular data points that you're asking for, but I do want to make one distinction about the declarations that are in this record. To my eye, the only declaration that speaks directly to this issue of the women who seek abortions is the declaration of Dr. Norton. And that distinction is important because, of course, some women welcome pregnancy. They want to be pregnant. They want to have a family. And those women may well know exactly when they get pregnant. They're taking pregnancy tests. They're going to their doctor to find out. That is not what we see in the context of women who need abortion. Some of them do. They're wanted, but they're
well,
wanted.
Why not? That raises something that I wanted to ask you about. Because so far we've been talking about how many women know they're pregnant. I wonder whether a better question to ask is how many women can't know they're pregnant. If we have a 6 week, or I don't even know how to characterize it, but if we have the current law go into effect, and if women who are sexually active have presumably given some thought to whether they want to have a child if they get pregnant, wouldn't it be a better question to ask of how many women can't know or how many women can know?
Well, Your Honor, and Dr. Ferris, starting at page 158 of the Joint Appendix, goes into the many reasons why women might not expect.
I mean, that gets into age. Age can have a huge difference. I mean, as women, we know that young women have very fluctuating periods.
Irregular cycles.
So age can impact. economic, worth, your ability to access pregnancy tests, information about pregnancy, the economics impacted.
Yes.
Your socioeconomic status certainly is important here. And while it's true that affluent, older women may well know that they're pregnant by 6 weeks because they're trying to get pregnant and are monitoring it, that doesn't account for all the women, as Justice Few has said, who can't know. So what are we talking about with those women who can't know they're pregnant by that time?
Well, I think all of those factors that Your Honor suggests they are factors that inform who could and could not possibly know. I think the other data point that I do want to suggest to Your Honor is that, as I mentioned earlier, we know that more than 90% of women nationally have abortions before the end of the first trimester. And so, although I don't have data specific to 6 weeks, how many people know, it is fair to say based on that data that by the end of the first trimester, the majority of women who do have abortions must know that they are pregnant because they have gotten abortions at that point. But again, 6 weeks, it is not, if you look at when people have abortions, it's not linear. It doesn't kind of go up in equal steps. 6 weeks is extremely low that people would know that they're pregnant to get in and have an abortion. And then it goes up much more steeply later in the first trimester.
I just want to frame why I was asking you that question. I didn't mean that as a challenging question to you. I really do want to know what is the right statistic to look at and what's the answer to the question, because it seems to me your best answer is that in SB 1, Section 2, subsection 8, the legislature has specifically referenced the importance of an informed choice. And if there are more than just a handful of women who simply cannot make an informed choice, that seems to me to be important in this balancing of whether the restriction that is placed on abortion in this statute is reasonable under the law. And I'm a little disappointed that we don't have more to go on in analyzing the extent to which that is a significant issue.
I think, Your Honor, to the point about when women, can they make an informed choice? I mean, I do want to emphasize, even women who know that they're pregnant at 6 weeks, or maybe 4 weeks.
I know that, but that's really kind of beside my point. If every woman knew they were pregnant at 4 weeks and had 10 days to decide and 4 days to execute, that's one thing. If no women know they're pregnant at 6 weeks, that's another thing. It's somewhere in the middle. And for us to analyze the extent to which this choice issue is important, we got to have a data point.
With respect, Your Honor, I think the idea that the women who are having abortions can uniformly decide in 10 days and 4 days to execute overestimates their ability to access funds, to access childcare, unpaid time off work, and access an appointment at one of the only 3 locations in South Carolina where they can do so.
I'm not disputing you on any of that, but the starting point of even what you said is the data point, and we don't have it.
And should a case-specific challenge be addressed here in a facial challenge as this is, or is it better suited for as an applied challenge?
No, Your Honor. I think an applied challenge would be wholly unworkable here for reasons in addition to the fact that women's pregnancy, if you are pregnant, you need an abortion at 6 weeks, 7 weeks, 8 weeks. The idea that, women one after another are going to make a state case out of it, I think is unrealistic. But I would say to this point about what women know, I do want to emphasize even our position is that this early in pregnancy, whether you know or not, there is a private sphere for you to make a decision. And whether it takes you 10 days or a month to figure that out, That is a decision that should be left to women.
So I agree with you on that. Well, up until your last statement, I agree with you that there is a private sphere in which a woman should be able to decide. But there's another side of the equation, because in our constitutional provision, it does not grant an absolute right of privacy. It conditions the right of privacy on reasonable restrictions. And I'm trying to understand, when is a restriction a reasonable restriction? For example, going back to this data point idea, what's the difference in the number of women who know they're pregnant and then have time to decide to have an abortion under the 22-week law or 20-week law or whatever it is, as opposed to the number of women who fit in that category on the 6-week law? What's the difference? And apparently we don't know the answer to that question either.
In terms of the number
of women who are, take all the difficulties that you cite. I don't disagree with any of those difficulties, but you mentioned a line, a graphic line. How does that line of women who know they're pregnant and have had a chance to think it all through, talk to their family, talk to their pastor, so forth, make a decision, and then go to a medical clinic to execute the decision within 6 weeks, how does that number compare to the women who are in that position before 20 weeks?
Well, I think just by looking at the share of women who have abortions at different gestational ages, we know that people who have abortions after 22 weeks, although that occurs outside of South Carolina or in South Carolina for certain narrow exceptions, it is extremely rare. So I can't put a number on it, but it's, at least at this moment.
Well, I'm going to let this go, because I think the important point for me is that we don't have a number.
Yeah, but do you know, Ms. Murray, are there studies like this? Are there studies, I don't know why there would be, but perhaps there are, that would show when women, most women, by percentages, know they're pregnant. Are there studies out there on that?
There are studies about women's decisional process, and one of them is in the joint appendix. I can look certainly for rebuttal to see whether there's information in there on that, about the reasons that women have abortions, and I think, that may give some context to the decision. I do think there is data, not specific to South Carolina, but there is data nationally where people have looked at the point at which people find out they're pregnant and the point at which they have abortions, and the reason why there is, in many instances, a significant lag between the two.
Well, one point that you could turn to is that this question probably should have been addressed at the legislative level too. And because if the legislature is going to come in paragraphs in section 2.8 of the 21 Act and talk about the importance of making an informed choice, they need to have some sense of how many women are denied that choice because of the early time frame of the ban.
Well, that's certainly a question.
I'll take that up with them.
All right,
Let me ask one final thing. I'll tell you, I'll wait till reply.
No, you go ahead.
No, just about data. I'm going on the data you presented. Now we're going to add 2 weeks to the data that you want us to rely on. But 44.5% in 20, 47.9% in 21, and then both 20 and 21, looking at the chart, 13 weeks, and you don't want us to believe it's 13 weeks, it's something else.
I think it's 15.
But it's 99.5+%. So that's a data point. It may not be when they discovered they were pregnant, but we know from the information you provide some data on the number and when abortions occur.
Yes, Your Honor. And I will say I think that is, South Carolina's numbers are somewhat unusual in that the only abortion providers in the state provide only to the end of the first trimester. So the dramatic drop-off that you see at that point in South Carolina is in part a function of availability of services after 14 weeks. I think that even under prior law, there were many South Carolinians who had to go out of state for care at points later than that.
That 99% does not represent the 100%. It just represents the 100% of those who are limited by the constraints imposed under South Carolina law.
That's correct.
Thank you very much, Ms. Murray. We've gone over about 28 minutes with your time. But this is a very important matter, and we still have issues to address with you. You didn't go through all of your grounds. I wanted to go through that equal protection ground with you again, and you have another one of, I believe it's due process as well as vagueness, I believe.
Yes.
That probably need to be addressed, and I wanted to make certain that the other side had an opportunity to address those matters, and we'll talk to them about them and see what they have to say, and hopefully give them sufficient time to do so, because we're going to talk to you about that when you come back.
Yeah.
Thank you very much.
Certainly, we were happy to rest on our briefs for some of this and take the court's lead.
Have we been too harsh? You're trying to hide from us now?
I'm sorry?
Have we been too harsh on you? That you're
I've got all day, Your Honor.
We've been rather easy today.
Thank you.
Mr. Hall.
Thank you, Mr. Chief Justice. Members of the court, may it please the court. I am Kevin Hall, and I'm here with the privilege of representing the Speaker of the House and the President of the Senate. At its core, this is a separation of powers case.
Why is that, Mr. Hall?
It is because we have three independent and equal branches of government, co-equal branches of government.
That we understand.
And decisions about policy and politics are left to the legislative branch. And what is being asked of this court by the petitioners is for the court to inject itself into and to limit the plenary authority of the South Carolina General Assembly.
Well, now, the General Assembly has plenary authority, but that authority yields to the Constitution.
It does. It does.
Now, what is being raised is a violation of a fundamental right granted by the Constitution. So I think you're off base on that one.
Do we have a privacy right?
We have a...
And it can be under this, I know you don't want to expand Article 1, Section 10, but it can be under the liberty interest of the Due Process Clause. Do citizens of South Carolina have a right to privacy?
In the context of searches and seizures, yes.
That's it?
Okay.
So when this court said in Forrester, this right extends outside of search and seizure, it is not limited to that, then we were wrong. And what you're saying now, you're overruling what?
So I don't have the right to go to where I want to eat lunch today. The state could regulate that. The state could regulate what road I take back to Greenville when I go home tonight. You wouldn't for a moment suggest the legislature has such authority, would you?
No, Your Honor, and here's the challenge. I think in each instance, and we see it on both sides of the argument, and we see this in the political arguments on both sides of the argument. Each time we try to account for every possible unforeseen scenario, every hypothetical, it's difficult. It's difficult, admittedly.
Well, let me give you a concrete example, because I thought this was rather preposterous in the reply brief. And I want to see if you think the state has the authority to do what the petitioners say that you'll have the authority to do if we rule in your favor. If we find the act is constitutional, the petitioners say under your construction of privacy, be it due process or Article 1, Section 10, that we, the citizens, would be powerless against laws criminalizing the use of birth control by married couples, requiring sterilization of individuals with more than 2 children, and so on. I would simply like for you to acknowledge that those tongue-in-cheek examples are beyond the purview of legislative authority.
They are, and there are other relevant constitutional provisions that deal with that.
So it wouldn't be a right under the privacy provision, it's under something else.
Well, it may be. I'll give you an example. The court is familiar with a castration case in the criminal justice context. Judge Pyle, a number of years ago.
Right. The Clemson case.
I believe so.
All right.
We all remember that one.
Yeah,
We know it. It has many names. Clemson case is a good name for it. There are others.
That case was decided under Article 1, Section 15 that deals with cruel, corporal, and unusual punishment. So there are other provisions and some of the parade of horribles that would be relevant.
But these two examples that I've just read to you from their brief, they say this is how far the legislature has the authority to go. I'm not suggesting for a moment the legislature would ever harbor any notion of wanting to pass such laws. But it's a question of power.
Yes, it is.
And I think there is something embedded, at least in due process. I'm not there on the privacy provision. But on due process, there's a liberty zone. There's a liberty interest for the government not to have the authority to unreasonably constrain people. Well, and to make decisions like this, which would be preposterous.
And we have an analytical approach set forth in substantive due process law about determining what are fundamental rights, what are fundamental interests. And in each of those scenarios, we could walk through that analysis. I think the challenge is and the difficulty is when the discussion gets more broad about what is reasonable.
I agree with that. But in these specific concrete examples, these examples would easily fit the Glucksberg standard of deeply rooted.
Absolutely.
And implicit in the concept of ordered liberty.
I agree with that. And that's why, again, and I say this respectfully, I say this in a political context when I have these discussions with friends, but more importantly in a legal context. I think we need to narrow in on the fundamental issue here. And the issue here is what does Article 1, Section 10 say? And what we do know from the history is that it has everything to do with search and seizure.
Well,
now, Mr. Hall, it appears that Justice Kitchener's question has not been answered by you yet. And if you're saying that the legislature would not fathom doing those kinds of things, you've yet to state what provision of the Constitution would prevent it, although you say there's a way to do it.
Well, here's the answer. Let's say in the incredibly unlikely event one of those statutes were to pass. We would have a lawsuit, and the lawsuit would focus on, among other things, I presume, substantive due process. And we would look at the behavior and say, is this part of our ordered system of liberty? Is this part and parcel of our history of freedom in the country? And if the answers to those questions were yes, we would say, hey, this is a fundamental right.
What take birth control? When did birth control come on the scene? Is it deeply rooted in American history?
Well,
would we be able to answer that question under the current framework we're given for analyzing substantive due process questions?
I believe you would.
You don't know.
Well, look, I believe you would.
I understand you want to win this case, but you don't have to emasculate the privacy rights of South Carolina citizens in order to do so.
Absolutely.
You started off by saying this is a question of the separation of powers. It is a question of separation of powers, at least in the first instance, if the question that we are to address is whether the regulation at issue is reasonable under Article 1, Section 8, or going under the due process analysis in some way. That is, at least in the first instance, a legislative policy question. But you decided to turn to the existence or non-existence of a privacy right in this sphere. Guess what? That's not a legislative question. That is a legal question. And if you want to win, I don't understand, and you want to win on the basis of separation of powers, I don't understand why you don't stay in the political arena and concede, yes, there are privacy interests at stake here, but they don't control the day, because those privacy interests can be restricted by reasonable means by our legislature, and the restriction of privacy in that fashion is a political question. You win there, probably, maybe, but if you want to argue over whether privacy extends here, now you got a legal question.
You know, I don't want to ignore the court's advice on how to win. I guess here's where the challenge is.
I didn't mean it. I didn't mean it as advice on how to win. I meant it as privacy is an issue here, but we don't want this case to end up restricting what Justice Kittredge was talking about late in his questions, because that's not what anybody has in mind.
Understood and agreed.
Privacy, and to the extent privacy is simply privacy, but certainly to the extent privacy is a component of liberty, goes way back and deeply into the history of South Carolina, long before the legislative session of 1970. You agree with that, I suppose?
I do.
All right. So let's not emasculate the privacy rights of South Carolina citizens in order to try to decide this case.
We don't need to, Your Honor, and we certainly aren't suggesting that you should. The point here is what does privacy mean in Article 1, Section 10?
All right. Along those lines, respond I've got a couple of questions. Respond to Ms. Murray's comment that Attorney General McLeod's letter held open the notion of the privacy right applying broadly to health. Because I don't read it that way.
I don't either. I will tell you that as I sat here and heard that, I was fumbling with the joint appendix, trying to.
He mentions it first in the context of health inspections, I presume.
That's right.
In restaurants.
It's on page, I can help you out, Mr. Hall. It's on page 947, volume 5 of the joint appendix.
And then explain to me what we are supposed to look at when we determine the scope of a constitutional amendment during a time when the entire 1895 Constitution was being reviewed by the West Committee and I assume others. Right. And then this privacy provision was spawned during those committee meetings. What are we to look at as far as the intent of the framers, the intent of the people, the intent of the legislature? What is the law? Because there is a case from 1927 that nobody cited that talks about that.
Your Honor, my understanding, what I think the analytical sequence is first the text. What does the text say? And when you look at the text and you see no reference to abortion, I think you can reasonably say the analysis can begin and end there. If you're not satisfied with that and you say, hey, that word privacy isn't self-defining, I'm not sure what that means, might that include abortion? Let's drill down further. I think you go through the West Committee process. We've done that at length in our brief. And what you see throughout the process is the sole focus initially was on surveillance, electronic surveillance, and then you see the notion of database, data aggregation.
Concerns about even the makeup of the U.S. Supreme Court. One person called them idiots.
Well, I won't say it was all tasteful, Your Honor, but I think what they were focused on is abundantly clear, and it was in the search and seizure context.
All right, so
our decisions are wrong in Forrester and Single.
That's not the point of my question. My question is, what are we to look at? Perhaps the question, channeling what Justice Hearn just said, what should we have looked at in Singleton, Forrester, Counts, and so forth, and what should the state have argued back then?
Yeah. I think analytically it goes this way. What does privacy mean? To answer that question, you look at the West Committee, look at the text first, you look at the West Committee.
When you say privacy, you mean in the context of Article 1, Section 10, not substantive due process.
That's correct.
Okay.
That's correct. And you say, what does it mean? And you look at what at the intent of the drafters, in this case the West Committee, and then the General Assembly with the change of a standalone sentence to the interlineation of 11 words. Then you go to the ballot. The word privacy, the word abortion don't appear in the ballot description at all. The only thing there is search and seizure.
Yeah, somebody needs to give me that page number because I can't. Yes. I know it's there, but I can't find it.
I believe it's 897. I'm going on memory. I'll ask one of my peers here to.
And I know many of my colleagues might not agree with me, but I want to read something to you from a case called Duncan from 1927. The fundamental purpose in construing an amendment, and that's a constitutional amendment, is to ascertain and give effect to the intent of its framers and of the people who adopted it. And the court must keep in mind that the object sought to be accomplished and the evils sought to be remedied. To me, you start with West Committee, you glom on to the legislature's perhaps debate and what was on the ballot. What I'm searching for is where the right, and I want you to be a devil's advocate for a minute. Where is the right to privacy in Article 1, Section 10 given any extension to bodily autonomy? I know it's there in substantive due process, but I want to talk about Article 1, Section 10.
It's not there. It's not there. There's no.
All right, if you move to substantive due process, is the right to an abortion deeply rooted? I know the notion of abortion has been debated for decades and decades, but is the right to an abortion deeply rooted in this state's history?
Absolutely not.
When did it become rooted? When was the seed put in the ground about the right to abortion? Was it 1963? Or I can't remember the year that statute was enacted, but was that when it was?
Your Honor, this is the fundamental point we make. It has never been a part of this state's history. not from the common law.
It's been a part of the history, but not deeply rooted, you say,
well,
in
a
your
right
brief.
to it has never been a part of the state's history except in extraordinary circumstances. This has been true forever. So this notion in a substantive due process sense that there's a fundamental right that's part and parcel of who we are in our history and a concept of ordered liberty doesn't hold up.
So your argument about,
because it's a loser.
So your argument about Forrester, Singleton, and so forth, those cases could either be distinguished or we would have to partially overrule them, because Singleton can be upheld on substantive due process grounds.
That's right. I would point out, for instance, in Singleton. Singleton makes a no analysis of our constitutional provision. It simply says, under Riggins and other federal court precedent, there's a due process issue here. It says, we think the same is true in South Carolina. It says, hey, Louisiana has a constitutional provision, a post-Roe provision, that has similar or the same language. What they said, we say. There's no analysis. There's no discussion.
So in your view, this provision only relates to search and seizure. So going back to Justice Kittredge's question about what would prevent the General Assembly channeling Ms. Murray's reply brief from enacting restrictions about contraceptives, that would not fall under the penumbra of rights guaranteed by the right to privacy. That is something else?
Well, I wouldn't acknowledge any emanations or penumbras here, okay? I would reject both of those. I would say that you go to the substantive due process analysis there. That's where they come in. They do not come in as a right to privacy here. We know the history of the right to privacy. We know what the framers intended. We know what the General Assembly intended. We saw them change the West Committee report, included exclusively in the search and seizure provision. We saw them draft a ballot amendment description that doesn't say privacy, doesn't say abortion. We saw the people.
Well, it doesn't say forced medical treatment either, but this court has extended the right to privacy to that. The
court has, and I would say, without picking a fight with a prior court, I would say that this court doesn't have to overrule Singleton or any of those other cases in order to decide this one. I would note this. Each time we've had a discussion about unreasonableness and the unreasonable invasions of privacy, the presumption has been that there is a right to privacy there, that abortion is part of that right to privacy. If we're going to talk about Article 1, Section 10, we've got to first determine whether abortion is part of privacy before we even deal with the adjective unreasonable.
Yeah, that's a question I have. Even if we accept Singleton counts, Forrester, lock, stock, and barrel, does that translate into plaintiffs win and there's a right to abortion?
Absolutely not. Absolutely not. The first question, the fundamental question is, does the term privacy in Article 1, Section 10 encompass a right to an abortion? And how do we learn that? We discern that through rules of construction that you engage in every day. And we know the answer to that question is no.
Why?
We don't, because we study.
Why do we look beyond what the words say? The words are very clear.
I'd be happy with that, Judge. I'd be happy with that. As I said, we start with the text. The text is silent as to abortion.
Well, is that really what we're looking at? Don't we? I mean, texts are silent about a lot of things the courts have decided are included. I mean,
Your Honor, this is why this is a separation of powers case.
Well, I got a question I want to ask. I think that it's not totally wrong, but it's maybe to me it's a little misleading to say that to frame the question around whether Article 1, Section 10 includes a right to abortion. I mean, very clearly the word is not in there, but it does include a right of privacy, and there are privacy concerns that arise around this question of abortion. There are confidential conversations that a pregnant woman would have with her spouse or her boyfriend, with her doctor, with her pastor. These are, to me, privacy concerns. It might change a little bit when you get to the act or to the procedure of abortion, but I personally don't want to answer this question over the extent of the right of privacy. But then you get to, in my analysis, you get to whether an individual restriction on the abortion is unreasonable in light of the privacy concerns and perhaps others that I outlined. And so to me, going back to my conversation with petitioner, I know I'm not going to substitute my own personal policy judgment for that of the legislature. That ain't going to happen. But I do envision that there could be a line past which a legislative policy judgment simply can't be justified as reasonable. I'm not saying there is, I'm saying there might be, and that's when the court can step in. And so I want to ask you some questions about the way this whole thing kind of went down. If we go back to 2016, in the 2016 Act, the legislature adopted the 20 or 22-week bill, however you described it, and identified in Section 13 of the legislative findings, well, actually it's 12 and 13, what the compelling state interests are. And I'm not trying, my question doesn't minimize those at all. I acknowledge those are legitimate state interests. Right. Now, and they arrived at the 20-week bill. So now we move to the 6-week bill, or the current bill. And the legislative interests are different or the same, I'm not sure. But my question is, what does moving from 20 weeks to 6 weeks do to in pursuit of the state interests that are articulated as the basis for these abortion restrictions? How does that advance the state interests that are articulated?
Well, the state interests that are articulated is obviously the protection, among other things, of the life of the unborn. And we know there's a 95% correlation between detection of fetal heartbeat activity and live birth. So we have a very precise connection between this point in time that is objectively knowable and outcome, which is live birth. So that's how it's related. Now, again, in this notion of sort of reasonableness, 20, 16, 8, 12, 12 and a half, is it 15, is it 13? How do we count? Those are legislative decisions. Those are legislative decisions.
You won that argument with me, right. Okay? But there's a line.
You say that that's unfettered, and I think what Justice Few may be getting to, and mine is, there's got to be some point where it crosses the line. It can't just be carte blanche.
I would use substitute plenary for unfettered. I think that, again.
Say that again.
Plenary.
Plenary is.
I mean,
better.
you're saying the same thing. She just said unfettered.
Well, look.
And I'm telling you that's limited by the Constitution.
It's not unfettered, and here's why. If we're limiting our discussion here exclusively to the privacy claim, it stands. The argument that I'm making is upheld there. There's no question about it.
I'm sorry, again, maybe I need to just lean forward.
Now look, are there other things that can happen in other contexts outside of the context of abortion that would trigger privacy analysis, substantive due process analysis? Certainly. And we would analytically work through those well-crafted tools. This court has made clear in Luckaball and in other cases, we all know the standard, right? We all have little charts and graphs with yeses and nos and rational relation and strict scrutiny and intermediate scrutiny. We go through that analytical process, that rule of law. But as soon as we start talking about what's reasonable, or there's got to be a line, or what would be fair or unfair, or that seems harsh. That's what my clients do.
That's why I'm asking you about the state interest that's being advanced, and you gave a good answer. It perhaps improves the correlation between those fetuses that are aborted and those that have a chance at life after birth. I get that.
Go ahead.
There's a 95% correlation.
And then the other thing that is mentioned here that I have some questions about, I'm not suggesting that somehow this undoes the conversation we just had. But in paragraph 8 of section 2, it discusses an informed choice about whether to continue a pregnancy. And I just wonder, to what extent did the legislature consider whether moving to this 6-week threshold restricted choice rather than enabled choice?
Well, the legislature made the determination that in making an informed choice, a woman had a legitimate interest in knowing the likelihood of this fetus's survival to full term based on the presence of a fetal heartbeat. In that
Okay,
context,
that makes good sense. But then there's this other weird phrase in there where they say the doctor's got to play the heartbeat to the mother. Like, what's going on with that? Because at that point in time, the abortion's already illegal. What does that do?
well, again,
It may have no significance, but I was curious about the phrase.
I think rather than a doctor saying, no, get on out of here, you can't do it, the woman knowing that it's based on the law and the presence of a heartbeat, and here is the heartbeat. She's in a position to know exactly what the doctor knows.
Can we say it's really not a heartbeat? It's an electrical signal?
You're
We're talking about a collection of cells less than a quarter inch long, and we're talking about we want people to believe there's a heart beating there.
Your Honor,
May I follow up on that, Mr.
Sure.
Hall? The American College of Obstetricians and Gynecologists, the American Medical Association, the American Academy of Family Physicians, the American Academy of Pediatrics, the American College of Physicians, the National Hispanic Medical Association, and the Society for Maternal Fetal Medicine all note that what this act considers a heartbeat is actually embryonic cardiac activity that occurs as a result of electrical flickering of a portion of the embryonic tissue. A true heartbeat does not occur until all 4 chambers in the heart have developed, typically around 17 to 20 weeks. Are you saying that all those groups, those hundreds of thousands of physicians that make up those groups, they're all wrong?
no, those are arguments they make to legislative bodies, and that's where they should make the arguments. Legislative bodies
So
here.
we can't consider them in determining whether this is reasonable?
Your Honor, the first question, the answer politely and respectfully, I think, is no, and here's why. The first question isn't one of reasonableness. The first question is whether the right to privacy, if you want to call it a right to privacy in the search and seizure context, attaches to abortion. And the answer to that is no. And so the question of reasonableness isn't there. With regard to the...
But is it really a heartbeat? Come on. Is it a heartbeat?
Well, whatever it is, we know that there is
I just told you what it was.
Well, she told
It's
me what somebody else
flickering.
told me it was.
If
Whatever.
you know anything different, then tell us.
Whatever it is, without quibbling over terminology, we know there's a 95% correlation between it and a live birth. So we can call it a heartbeat, we can call it fetal activity, we can call it a flickering, we can call it whatever
Well,
we
the
want.
act the General Assembly is debating now would have that start at birth or at fertilization, they would say. So, I mean, we have a moving target here. But let me ask you something.
Sure.
We certainly all are aware that Dobbs returned this decision to the people and their representatives. And everyone on this court is well aware of the plenary authority of our General Assembly. But why didn't the General Assembly put this to the people in a referendum?
I don't
Wouldn't
know.
that have been the best way to know what the people of South Carolina really want on this issue?
Well, the General Assembly certainly has that prerogative if they want to do
They
it.
could have, and in fact, a motion was made to do that, and it was said to be out of order. Isn't that correct?
Your Honor, I think that's right. I don't know, but I will tell you that...
Why was it out of order? I mean, why wouldn't that be important for all of us to know what the people think?
Your Honor, on the floor of the General Assembly, I think those questions directed to the legislative leaders would all be the right place. In terms of whether that's the best path forward,
The legislature is the people.
it is. It's their elected representatives. And notice whether it goes to a ballot, starts with the legislature, whether the people's decision or viewpoint or advice, whatever you want to call it, in response to the ballot initiative, goes back for ratification. So be that good, bad, likable or unlikable, the fact of the matter is the General Assembly has that authority, and it's not debated.
And it is unfettered in your view. Plenary equals unfettered. In this court, because of separation of powers, we really shouldn't be here today.
The ability of the General Assembly to act is limited in many ways. We've got a bicameral legislature. We see them right now wrestling over this very topic, right? So there's political checks there.
Well, it's not unfettered because your authority is bound, the boundaries are the Constitution,
Absolutely.
constitutional provisions.
And again, the question, the fundamental question, the only question in terms of privacy, which we've been discussing and devoting our time to, is Article 1, Section 10. What does it mean?
Can I ask a question, Chief?
Yes, please.
Does the Planned Parenthood argument fail under substantive due process, or does it succeed? And give me a reason why or why not.
It absolutely fails.
Why?
It fails because in 1712, we incorporated the English common law, which had largely outlawed abortion except when the life of the mother was at stake. It fails because in 1883, the first time we as a state codified the law, it was a felony, except in circumstances where it was necessary to preserve the life of the mother or the child. All right, that would be...
So at the most, the right is perhaps rooted, but not deeply rooted. And we have to decide which one of the two it is.
Well, even if it were deeply rooted, it's deeply rooted only... the right to abortion is only deeply rooted in the context of a woman's ability to survive.
What do you say about State v. Stedman?
Your Honor, I'm drawing a blank when you say the case name.
1948 case in which the Supreme Court of South Carolina interpreted the 1883 Act to apply only to abortions after quickening. In other words, I get you're talking about the history of banning abortion. According to our court in 1948, the 1883 Act actually permitted abortions up until quickening.
Well, you know, I went and read about quickening. All right, just the phrase, the quicken the dead.
Yeah, I had to Google it myself.
Well, it is. You know, I know the term and the phrase, the colloquial phrase, the quicken the dead, meaning the alive and the dead. And the notion at that time that the word quickening was whether something was alive. All right? So with time, and we see this throughout the law, the whole notion of quickening has gone away. And obviously that's a 1948 case with many enactments after.
Right, but I mean, you may be making a great point, but what I was getting at is the 1883 Act was not interpreted as a total ban on abortion. It was interpreted as a ban on abortion after a certain point in time in the pregnancy, which I think is somewhere after 20 weeks. I don't know, certainly after 6 weeks.
Your Honor, I can't quibble with you there because I simply don't know, but let's assume that's right for the
Would that be considered deeply rooted?
The point would be, let's assume for a second that chronology is accurate. I'm not in a position to quibble with you on it. That would be one blip in hundreds of years.
Why would that be a blip? Deeply rooted means deeply accepted. The fact that they allow abortion at a certain time necessarily means they outlaw abortion at a different time. The regulation and restriction of abortion has been throughout our history. So the notion that there's a consensus for the approval of abortion could not be deeply rooted.
Well, that's right. When I'm saying deeply rooted, I'm talking about the life of the mother. I apologize, Your Honor. Let me be clear. When I say, look, we're talking about interests, right? It has been true from the beginning that the interest of an unborn child has been at the heart and is deeply rooted. The commitment to the protection of that life has been deeply committed forever.
I misunderstood your argument.
Well, I may have misspoken, so let me be clear. The only time we see consistent impingement, I don't mean it pejoratively, but bumping into that is when the life of the mother is at stake. We see other times, we see it now, rape, incest, fetal anomaly, bodily impairment. We see other notions and concepts. But the two fundamental interests that are always there are the life of the unborn, deeply rooted, protecting it, and the life of the mother. Well, so again, when to Justice James' question about substantive due process, is the right to an abortion deeply rooted? Absolutely not.
Well, I'm not going to argue with you on that point, but you brought up the 1883 Act. And what I'm saying is the way the 1883 Act was interpreted was actually to grant the right of abortion up until the point of quickening. And that has, so if you read Stedman, is that what I said? Whatever the case name is, Stedman, the way I suggested, I'm not saying that's the way to read it, but if you read it that way, there has been since 1883 a right to have an abortion up until a certain point in time. And I'm not saying that means deeply rooted. I don't actually agree with that framework, but you brought it up, and I'm just asking what you think the case means.
Your Honor, I appreciate the question, and I'm not in a position to quibble with you on it. I will say this. I don't think and the months leading up to Roe, that was the norm in South Carolina, the law.
I mean, yeah, you read the case that we decided in 1973 overturning the Lawrence. You read Lawrence, I mean, you can just see the reluctance of Justice Littlejohn wrote the opinion. You can see the reluctance. He said, well, we can't have any choice. We actually have to reverse this conviction.
Well, again, and to me, Lawrence is a fascinating case. I mean, if ever proximate to the time of the adoption of the amendment, anybody would have been focused on a right to an abortion under the Privacy Act, it would have been Dr. Lawrence. He was sentenced to 5 years in jail and a $5,000 fine over in Florence, lost his license to practice. Never once at the trial court. He didn't have some slacker trial court judge, right? No, he had a jurist. He had George Bell Timmerman. No mention of any right to privacy in the South Carolina Constitution. In 1972, a mere year after adoption, what happened when it went up on appeal? When it came up on appeal, General McLeod appears again, right? There's no mention anywhere in the court's opinion, this court's opinion. It says, as Your Honor says, we don't have a choice. We're only doing this because we got to.
Because of Roe versus Wade.
Because of Roe. It says the entire argument, quote unquote, the whole contention was Roe. Now, this is a man whose incarceration is dependent on the outcome. The entire argument, the whole contention was Roe. No mention of the 1971 Privacy Act. Dr. Lawrence didn't say it. His lawyers didn't say it. Trial Judge George Bell Timmerman didn't say it.
I love your argument because it reminds me of the Attorney General's failure to ever say anything about limiting the right of privacy to electronic communication or to search and seizure. I read all the briefs. I went back and read every brief that the Attorney General has ever filed in a right of privacy case, and they never mentioned it once.
Well, look, it's fair to say that it wasn't raised. It is remarkable that in the record there's not at least a discussion of it. There's no mention. There's no mention. And again, we have this battle about what was in newspapers at given points in time. If the argument is what did they mean based on what the West Committee said, what the General Assembly said, what the ballot question said, and what the voters thought it said, this is a hands-down winner because it cannot be reasonably suggested that the term privacy in Article 1, Section 10 had anything to do with abortion. Nobody believes that. Nobody knows. Everyone knows that.
Do you think it had anything to do with a person having the right to make his own medical decision?
Not when it was inserted in the search and seizure provision, no.
Does a person have the right to make his own medical decisions?
Yes.
Now, what would be the basis of that right?
Substantive due process.
Mm-hmm.
A fundamental right.
So whether or not to get an abortion, would that fit in there?
Well, we're conflating
we're not conflating. I'm asking a question.
All right. The question is medical treatment, and medical treatment is being defined as abortion. Medical treatment in most other contexts deals exclusively with one interest. That is the interest of the patient.
Okay.
When medical treatment, if we're going to call it that, involves another compelling state interest, it's a different question.
All right. Thank you very much. Your time's expired. At this time, we'll hear from a Mr. Lambert, I believe.
Thank you, Your Honor.
Mr. Lambert, please share some of that wisdom you have on this.
I want to know what page the ballot is on.
I believe it's on, may it please the court, Mr. Chief Justice, I believe it's page 878 of the Joint Appendix.
It's not on page 897.
I believe it's 878.
All right, so and that's my only question for now.
There have been a lot of points that have been made so far this morning. I want to start with two brief ones to pick up with where the court's question.
It's not on that page.
Is it not?
Is it?
Somebody find it.
We will find an answer before we leave the room.
Nobody must have thought the West Committee was all that important in the 1970 amendment to the Constitution.
No, that's a joint resolution. Yeah. I'm looking for the ballot.
He wants the ballot, not
Well, a
the
copy
resolution.
was pasted and transferred to briefs. It's cited to the joint appendix, but it's in the briefs.
Okay, got it.
That's not the actual ballot.
Not the ballot.
It's not the ballot itself, it's a link that says it must be printed on the
Okay, got it.
So that is the valid question.
Thank you.
If I may, Mr. Chief Justice, the argument's covered a lot of ground this morning. I'd like to pick up with 2 quick points with where the court left off with Mr. Hall. The first, as to substantive due process and what's deeply grounded, I'd ask the court to look at pages 10 to 16 of the governor's brief that covers the history of the state's regulation of abortion. And Justice Few, as to the issue of quickening, I would encourage the court to read the Supreme Court opinions in Dobbs, starting at page 2249, where Justice Alito has a long discussion of quickening as an evidentiary rule before medical technology allowed us to know whether or not the unborn child was alive. The second brief point goes to the conversation before as to what is this, Justice Harn? Is it a heartbeat? Is it cardiac activity? Whatever it is, Mr. Hall's correct. There's this 95% correlation. But I would point the court to page 43 of the governor's brief. Just weeks ago, Planned Parenthood's own website referred to a very basic beating heart and circulatory system developing during weeks 5 and 6. They have since changed that to refer to a part of the embryo starts to show cardiac activity. So whatever the language is, clearly it's evolving among the discussion and even with my friends on the other side. So those 2 points aside, I would like to discuss why the history is important. And Justice Kittredge, as you notice, the history here does strongly support the idea that privacy in Article 1, Section 10 has something to do with government surveillance and obtaining of information. But Justice Harn, to some of your questions about aren't there things in the record that support the petitioners?
Let me stop you there, Mr. Lambert. Let's say you're correct, perhaps unintentionally, but don't provisions of this act bring the privacy provision, perhaps through the back door, perhaps unintentionally, but into our framework for deciding this case? Isn't the reporting requirement of the physician necessarily a connection with law enforcement that deals with the privacy provision? And perhaps nothing else in the act deals with privacy. That's debatable. But I'm just saying, if I accept the premise of the limitation of your construction of the privacy provision, isn't it back in play because of the obligation of the physician to report?
If that's the case, Justice Kittredge, it would be in play only as to that provision. And I would note that the Act in Section 7 has a severability provision. And I don't think you can then impute the entire privacy provision onto the entire Act. So if there's any application here, it's very limited. It doesn't go to the sort of first order question of the Act's restrictions on abortion post-fetal heartbeat. Justice Harn, I do want to focus on these couple of places in the record. The petitioners cite on page 14 of their blue brief a statement from Mr. Sinkler, but even they admit that it's in the context of electronic surveillance. And if you read that entire section of minutes, they're talking about electronic surveillance and criminal procedure. So it has nothing to do with abortion, bodily integrity, or medical decision-making. They also point the court to the appendix.
So your position would be that State v. Singleton was wrongly decided when it extended it to forced medical treatment?
Your Honor, I think Singleton is at least distinguishable here for 5 reasons. We're not asking the court to overrule Singleton in this context. But if I may, 1, Singleton involved an entirely personal decision. Even the United States Supreme Court in Roe noted
what could be more personal about a woman's decision to have an abortion?
The Supreme Court in Roe, Your Honor, recognized that abortion was, quote, inherently different. That's page 1.
I'm asking you. I know you're not a woman, but what could be more personal than that decision?
Your Honor, there could be any number of things that are more personal.
Name me one. I know all the women in the courtroom who happen to be mostly on this side, interestingly.
Your Honor, I would think...
We all want to know. What would be more personal than that, Mr. Lambert?
How about physician-assisted suicide? It would terminate that person's own life. That is illegal under state law. And Justice Kittredge, if I can jump away from Singleton, I do want to get back to these points about limiting principles.
Well, okay. Well, I thought you were going to talk about Singleton being distinguished for 5 reasons.
Sure, I'll finish Singleton.
Is that in your brief?
Parts of it are, but let me just give you 5 quickly. 1 was it's inherently personal. It's fundamentally different than other privacy rights. Roe even distinguished abortion from Griswold. 2, it allowed for forced medication in certain circumstances. So whatever Singleton means, it's not necessarily this sweeping right that my friends on the other side call it. 3, it lacks any analysis of the history of Article 1, Section 10. That number 4, it relies on a Louisiana case that looked at a constitutional provision there that was enacted post-Roe, and that Louisiana decision, if you go back to it, has a law review article from Louisiana that talks about how their constitutional convention might have evidence. And number 5 is Singleton does invoke federal law. Federal law, when it comes to abortion, both in Casey with the plurality and Justice Ginsburg's dissent and Gonzalez v. Carhart, rejects the idea that abortion, in Justice Ginsburg's words, is based on some generalized notion of privacy.
And perhaps 6 is dicta.
6 is dicta, and I think on that point, Justice James Forrester is also dicta. Forrester talks about it being outside the search and seizure context, Mr. Chief Justice, as your question noted. But Forrester,
this dicta, we've cited it many times.
That is true, but if you look at Forrester specifically, it was ultimately about, did the police, 1, have to inform the defendant of her right to refuse consent to a request to search, and then 2, the ultimate issue was whether the officer search in that case of ripping the lining out of the purse to find the drugs went beyond her consent. That case was in the search and seizure context. So there's no way that a line about this one provision applying outside of that.
The statement was still made that
it was, Mr. Chief Justice.
That provision of the Constitution applies outside of search and seizure. That is correct. That's what the case said, right?
It says that.
So are we to ignore that?
Your Honor, this court has said often that dicta is not controlling on the court, and if it's dicta, it's not controlling. If you believe that is the holding.
Well, I'm from the Scalia school, if you will, when we talked about dicta. He says there's no such thing. If a court says it, that's what the court means.
Yes, sir, Mr. Chief Justice. If I can move on to...
I've made it clear in my comments here that I'm an advocate of the right of privacy. I think South Carolinians deserve and have a right of privacy extends into all areas of our life. That doesn't answer this question. It simply poses the question of whether the government action is a reasonable invasion of that right of privacy. If I'm writing an opinion in your favor, I'm using Singleton to support my decision.
I would...
Because not to distinguish it. Singleton recognizes the right of privacy, but talks about the limitation that it has in that context. And the language is, an inmate in South Carolina has a very limited privacy interest. Now, why wouldn't you make that argument here instead of trying to emasculate the rights of privacy of all South Carolina citizens?
Justice Few, I think...
It's a rhetorical question. You don't have to answer it.
Fair enough. But I do want to turn to a topic you did raise earlier, which is about that word unreasonable. Because if you do find that somehow privacy in Article 1, Section 10 is going to encompass abortion somehow, the question, as you noted, is the regulation unreasonable? And the common law...
Unreasonable as a matter of law is what I said.
Correct. Yes, sir. The common law has often analyzed what is reasonable and not. And it does that by looking to history and case law and statute to determine it. And if you look back at that law in South Carolina, it is perfectly clear that the state has consistently protected unborn life. So whatever happened in 1973, which was Roe, that led to the 1974 Act was, as the Supreme Court said in the United States, the arrogation of authority and taking it away from the people. When the people were making these decisions, their history and tradition was protecting unborn life. So, and this is a critical point, I think, in this case in determining what this means. The 1970 Act prohibited all abortion, this is Act 821, all abortions except for maternal life and health, rape, incest, or fetal anomaly. The same General Assembly that enacted that law is the General Assembly that put the revised Article 1, Section 10 on the ballot for the people to decide. It is inconceivable that a General Assembly would have in 1970 enacted a law restricting abortion except for these exceptions, and then turned around and passed a constitutional amendment for the voters to vote on that would implicitly repeal the statute they just enacted.
Well, let me ask you this then. Does it matter what the voters thought that meant?
Of course it does. This court has said that, Mr. Chief Justice.
Okay, so you want us to base our decisions solely on what the legislature thought they were doing?
Not at all, Mr. Chief Justice. I'm pointing to multiple things that all go in the same direction.
Tell me where is the evidence that the voters meant or understood that provision to mean what the legislature is now, or what you say in the legislature intended it to mean?
As far as I know, there are no public pollings or surveys to do it. But what we do have is circumstantial evidence as to what the public understand. And if you look at pages 18 and 19 of the governor's brief, we point contemporary newspaper articles.
You talking about the state newspaper?
Yes, sir.
How widely circulated was that?
It's circulation.
Was that in every little nook and cranny in South Carolina where those votes were taken?
I don't know what its circulation was 50 years ago, Mr. Chief Justice. But what I'm saying is the other side has pointed to nothing other than one single op-ed from the Greenville News from a year prior and an article that discussed an abortion lawsuit in Washington, D.C. The compelling evidence in the record, and certainly the weight of the evidence in the record, is that the people understood and the general consensus was this provision in Article 1, Section 10.
What is the weight in the record other than your state newspaper article?
The fact that you have the voters approving something that, as Justice James said, is talking about search and seizure and not talking about privacy. At the end of the day, the other side, my friends on the other side, Mr. Chief Justice, are the petitioners. They bear the burden to show that privacy falls within this language, and they can't do that. And I think, Justice Kittredge, this gets back to the limiting principle questions. On page 3 of their reply brief, the very first argument my friend on the other side makes is that the reason abortion is within Article 1, Section 10 is because there is no evidence that abortion was meant to be excluded from Article 1, Section 10. By that logic, this provision is going to cover a host of things, including physician-assisted suicide or the use of marijuana in the house at home. But no one's ever suggested it means that broadly. The fact is, there's no limiting...
It is true, isn't it, Mr. Lambert, that the General Assembly did not include a provision that would have made it clear that this provision was limited to electronic surveillance.
To communication.
I mean, they could have put that in, too. I know we're saying what they didn't put in, but they didn't put that in, right?
They did not, Justice Herm, but that doesn't mean...
They did discuss it, though, didn't they?
They did. And what it shows is they wanted something...
decided not to do it. Even though they discussed it, it was right there in front of them.
Doesn't that mean
prepared.
It does mean something, and we're not suggesting it for a moment that it does not. Well, what they said they weren't going to do, what they rejected, was about intercepting communications. What they left was a provision that was broad enough to account for advancing technology. So the folks on the West Committee and the voters in 1970 probably had no conception that there would be drones one day. There would be the internet. There would be cell phone location data. Those are things that might fall outside of the search and seizure context. I mean, we know the federal government has tried to purchase cell phone location data. It might well be that the unreasonable invasion of privacy provision prohibits the South Carolina government for doing that, because that's an extra protection we have. But it's clear that these protections are about the government using technology to obtain information. Simply put...
Thank you very much, Mr. Lambert. I hate to cut you off, but it's 10 of 12 at this point in time, and we still have one more from your side here, then we still have rebuttal. We will take a break before rebuttal.
Thank you, Mr. Chief Justice.
A reply, I should say, either the same.
Mr. Chief Justice, may it please the court, Thomas Heydrich for the state, Attorney General Wilson, and Solicitor Wilkins.
Thank you for joining us today, sir.
No, thank you very much. Pleasure to be here. As the third person to speak on behalf of the respondents, I know y'all are probably tired of hearing from our side, so I'm going to try to keep my points
We're never tired of hearing good stuff.
Well, I can't promise you what I'll say will be good, but I'll try to make it helpful. And in that vein, I'm going to attempt to respond to some of the questions that y'all have asked already, particularly paying attention to some of Justice Hearn's concerns about the reported rape exception, Chief Justice Beatty, some of your concerns about vagueness. But I'd like to really start with the question Justice James asked initially, and that's about what is the relationship between the history and the text in this case. And I understand that Justice Hearn may say the history is of not much value, but I think that we need to look back to the Court of Appeals decision in State v. Austin, where Judge Sanders recognized that Article 1, Section 10 really is a fairly unique constitutional amendment. And it's unique because we are in such close proximity in time to the intent of the framers and the people who adopted that provision. In that opinion, he said this is in some ways an easier case to decide than if it was a pure Fourth Amendment case. And that is because of the proximity of that history. This is in response to a case that Justice James raised as well on the relationship between the text and the history. But I think that we really have to view the text and the history as overlapping. And we tried to make that point in our brief. We didn't cite a case from the 1920s, but we did cite a case from 1881, and that's City of Charleston versus Oliver. And so petitioners are quite right that the privacy right needs to be interpreted according to its ordinary and popular meaning, but not the ordinary and popular meaning in the abstract, not what I may think privacy means, but what the people who framed and adopted that provision meant. That, I think, was pretty much a direct quote, although a little bit of paraphrasing from that Oliver decision.
What case is that?
That's City of Charleston versus Oliver, and the site to that is 16 SC 47.
What page of your brief?
That was, I think, I don't have the page of brief at the top of mind, Your Honor, but I think it was in the portion of the textual analysis of Article 1, Section 10.
The governor's brief?
Oh, no, sorry, the Attorney General's brief.
Attorney General?
Yes, sir.
Looking at the wrong one, okay.
But moving on to the reported rape exception, I do understand that that is a concern of yours, Justice Hearn, in particular. As an initial matter, I think there was some suggestion earlier that perhaps the rape reporting requirement would run afoul independently of Article I, Section 10. And I think that was your point, Justice Kittredge. But I would point to the evidence of the fact that there was a contemporaneous enactment, and that was the 1970 abortion law that contained a similar reporting requirement. In fact, that reporting requirement was even more stringent than the reporting requirement we have at issue here. The 1970 law actually mandated that the sheriff in the county in which the rape was reported issue a warrant before the abortion could be performed. In that sense, our rape reporting requirement is actually a liberalization.
Was that provision tested in the courts?
No, Your Honor, that provision wasn't tested in the courts, but I think it is strong evidence to suggest.
We have a lot of crazy laws from years ago. I mean, how about all the laws that didn't even allow women to be lawyers? I mean, we're not really concerned with dated laws like that.
I think that's right, but I think that even if you do somehow think this could encompass a privacy right, and I think this was a point Justice Kittredge made earlier, that law and that reporting requirement is in fact reasonable. And it was actually Justice Few who made that point. I misremembered. But if you look at the Pennsylvania court's decision in Fisher, which is also cited in our brief, it explains why there is a rational basis for those types of reporting requirements. Enforcement of the criminal law is certainly one, but there are other state considerations at play. Moving on to the vagueness argument as it pertains to the death or permanent injury exception, we really think that petitioners have an initial standing threshold problem on that point, but even moving past that, we think the death or permanent injury exception actually imposes an objective requirement that is easy to understand and readily ascertainable. If you look at the code section 4441.690 and 4441.4310, that employs a reasonably prudent physician standard. Now, that's an objective standard that we see not only in the common law, but we also see in our statutory law for medical malpractice cases. I think that there's a lot of authority from other jurisdictions that have upheld that standard as not vague. We'd cite the Carlin v. Faust case, that's out of the Seventh Circuit. And we also think that the Alliance for Hippocratic Medicine did a very fine job in their amicus brief of explaining how physicians can reasonably apply that standard. But you don't have to take their brief at its word. You can look to other district court decisions that have applied similar standards. We'd cite the Rebuttal case within a district court case out of Massachusetts, which stood for the proposition that a similar standard protected ectopic pregnancies. So in other words, we really do think the death or permanent injury exception is not vague, and we think it is readily ascertainable. There was one other point that I wanted to make in response to a comment from Justice Kittredge as well, and that was the import of the Singleton decision. We do really think that Singleton is an aberration. We don't think it is supported by the history of the West Committee, but we would suggest that Singleton itself, and I think that Mr. Lambert recognized this, has a limiting principle that you could apply in this case.
You're looking at me, but you accused Justice Kittredge.
Oh, no, I'm sorry. I'm sorry.
You need to apologize to Justice Kittredge.
But Justice, I'm sorry, but we do think that Singleton actually imposes a limiting principle on its own right. In that case, it recognized that the privacy right at issue was not absolute, but could be conditioned on the right and respect for a separate autonomous being. That's really what we think is the case.
That's right. We didn't need Singleton to tell us that the privacy right is not absolute.
No, and I think that's right, Your Honor, but I would respectfully suggest that Singleton could be read to stand for the proposition that any privacy right that Article I, Section 10 protects is limited out of respect to other living beings. And in this case, the state has made a reasonable determination that a fetal heartbeat is worthy of that protection.
What rights of privacy do South Carolinians enjoy because of this provision in our Constitution?
And so I think that's a great question, Justice Hearn, and I think it really goes back to how do we read the trilogy of cases, beginning with Forrester, Weaver, and then on to Counts. And I think that you are right. There's some dicta in those decisions to suggest it is outside the search and seizure context. But when you read those decisions holistically, I think they really stand for the proposition that the privacy provision was meant to operate as a Fourth Amendment plus. And so it was really meant to provide additional protections in the search and seizure context, not only in the criminal law context, but in the administrative law.
No, but if that was the case, why did they mention right to privacy then? They just could have had the provision about searches and seizures.
Well, because I think that there was concern, Your Honor, respectfully at the time, that language about search and seizures might not reach specific objects. So, for example, it may reach a person or their belongings.
Okay, well, getting back to my question, because I know Justice Few's expressed his views, and I share them, that South Carolinians do have a right to privacy. You obviously, you all, do not think it extends to a woman's decision to have an abortion. What does it extend to?
Your Honor, I think that right to privacy really provides, like I was saying, heightened protection in the context of searches and seizures. So it's not only a criminal search and seizure, but it might also be an administrative search and seizure. And that's really where the concern and the language in the West Committee about health records, tax information. I think if you look at the minutes, they were actually talking about the prospect of tax.
What is the basis then of other privacy rights that you concede that South Carolinians have?
Well, I think, Your Honor, I think that Mr. Hall and Mr. Lambert briefly addressed this point. There may be some privacy protections that are protected in the common law. That's not a constitutional issue, obviously, and I think petitioners attempt to invoke those sources really fall flat.
It's not in the common law. There is no right to privacy.
No, Your Honor, I think there is a specifically enumerated right to privacy in Article 1, Section 10 that is largely limited to the search and seizure context.
All right,
Although it doesn't say that.
So our automobile stop cases, we can be really, really restrictive on law enforcement's ability to search a vehicle. We can go Fourth Amendment plus.
I think that's exactly right, and I think that's what you were getting at.
Okay, and so we can really, really look hard at all law enforcement searches and seizures because we have a plus.
I think that's exactly right.
And so you would advocate for the Attorney General that we should probably start doing that.
I would advocate that this court should apply its precedent on that point.
Well, but if it's Fourth Amendment,
we overrule our precedent.
if you've taught us that it's Fourth Amendment plus, we can not only modify Singleton and so forth, we can really, really be on the lookout.
I think that it does provide a ceiling to Fourth Amendment rights. That's right.
Let me ask you about, before your time expires, we talked about vagueness. We still have not addressed this conflict that was the basis of the injunction in the first place. How do you address that?
Well, I think that's a great question, Chief Justice Beatty, and respectfully, I think our initial position is, one, there really is no conflict. This type of provision is actually relatively common in South Carolina law. In our brief, we cited a comparable provision that was in a gambling case, and it really stands for the pretty
Because it's in another provision somewhere else doesn't mean there's not a conflict. I believe this court said those two provisions, SB 1 and 4110 to 80, conflicts.
Yes, Your Honor. I think I was just trying to make the initial point that there are certain provisions that do not conflict.
Well, how do we deal with this one?
I think that in the event that this court were to determine that there was a conflict, I think you would revert back to the standard rule that the later in time statute controls, and therefore the heartbeat bill would control if there was.
Even though the statute itself says it's not repealing 44, 41, 20.
Yes, Your Honor, I think that's generally right. But again, our baseline position is we actually.
So we'll then make that decision for the legislature then, something you told us we can't do.
Well, I think it would be guided by a long-standing principle that the later in time statute would control, respectfully, Your Honor.
All right, thank you very much. We'll take a 10-minute break at this time. Thank you. Ms. Murray, in reply.
Thank you, Your Honor. I'd like to begin by noting what struck me as peculiar about the arguments on the other side. Despite 3 attorneys, more than 45 minutes of argument, I still don't know what the state's position is as to why the General Assembly could not mandate sterilization or forbid married women from taking birth control upon pain of criminal penalties. They say maybe it's in the common law, maybe it's in substantive due process. It's not clear to me whether it's federal law, is it state law? That ambiguity certainly is cold comfort to the women of South Carolina whose lives and bodies are affected by laws like Senate Bill 1.
Well, everyone here, I think everyone in this courtroom, everyone in South Carolina believes there's a right to privacy, as that word is stated colloquially, just generically in the abstract. But here it's in the Constitution as a constitutional term of art. It must have a fixed, ascertainable, defined meaning that can be understood and addressed in a legal framework. And that's what, at least I think we're trying to do, is to cobble that together to understand what that definition is as a legal term of art and not just a generic in the abstract term.
Yes. I think as we cited in our reply brief, this court in fact had talked about a right to privacy and what that meant before 1970, 1971, and had already defined that term. So there is a definition that was in place as a background principle of law when this provision was adopted.
We had that issue in Dykes, and Justice Hearn had a respectful disagreement as to the result in the case, but I think we all understood there's a right to be left alone. It's just embedded in our nation's history, in our constitutional framework.
Correct, Your Honor. I do think the assertion on the other side that I've heard, and I know there was quite a bit of discussion about substantive due process as a potential alternative way that one could protect bodily integrity, we would say including abortion, and in fact we've raised a substantive due process claim. What I did not hear the other side address, and that I think is again, cold comfort to the women of South Carolina, is their position that any substantive due process argument could only invoke rational basis review. That would mean that there's nothing separating a law that forbids use of contraceptives, forbids abortion, from a law regulating, I believe, as you had suggested, where you go for lunch. Those laws would be treated the same. They would get rational basis review under the state's position. And certainly that is not what we think was intended by the addition of a constitutional right to privacy.
I'll make this comment, and I defer to the others, but you have got to get from the phrase constitutional legal term of art, privacy, and is it a short distance? Is it a bridge too far? I don't know. To a fundamental right, because you have got to put your hooks in strict scrutiny. If you don't put your hooks in strict scrutiny, I'm not sure where you land. So there's got to be the nexus between, it's got to be a fundamental right so you can put your hooks in strict scrutiny review.
I will say, Your Honor, I think in Singleton, this court, although it didn't say that it was applying strict scrutiny, it certainly adopted a categorical rule that even where someone is a danger to others, that person cannot be forcibly medicated if it is not in his own best interest. That, to me, rings in strict scrutiny. Singleton was a bodily integrity case, and as Justice Hearn points out, the experience of pregnancy is an intimate experience of one's body. So I think Singleton already supplies, in part, what this court could rely on for ruling in our favor. I will say as well that to the extent that this court considers history, and there was a lot of discussion about prior regulation of abortion. However, as Justice Few pointed out, under the common law, abortion was legal until the point of quickening, which, as we provided in our reply brief, there's evidence there. We cite a case there where the court said it's essentially impossible to have quickening before the third month of pregnancy.
I simply raised the question, and Mr. Lambert schooled me on it by educating me or telling me that actually that's a standard of proof, not a cutoff in time. In other words, the state was unable to prove an illegal abortion unless it had evidence of quickening. Otherwise, there's no evidence that the child was ever alive. Now that's what he harkens back to Dobbs on that. So I just want to point out, I was just simply asking a question. I appreciate you giving me credit for saying something substantive, but I just asked a question.
I do want to point out, though, in the Stedman case, and I'm looking here at page 7.
Which case is that?
The Stedman, State v. Stedman, that involved this issue of historical regulation of abortion. The court said at common law, an abortion produced with the woman's consent was not a crime unless the woman was quick with child. That is, when the embryo had advanced to that degree of maturity where the child had a separate and independent existence and the woman was herself felt the child alive. It then went on. I think what the other side has said is, well, the legislature has the freedom to say at this point in time, we're going to, I suppose, forget about the history and assume that there is this evolving sense that the legislature could legislate earlier. But of course, in Stedman, this court also said, it's not material whether, speaking with physiological accuracy, life may be said to commence at the moment of quickening or at the moment of conception or at some intervening period. In contemplation of law, life commences at the moment of quickening.
So then just to make sure that I and we understand the point you're getting at, you're simply arguing whether we apply a rational basis analysis or a strict scrutiny analysis.
No, Your Honor.
Because clearly the state has the authority to come back. If that was the rule, the state has the authority to change the rule.
And if the point of quickening, as the state suggests, is a point with legal relevance because of the history, then the point of quickening was typically understood at roughly 4.5 months of pregnancy, beyond which our clients don't provide abortion. So I just want to.
What's the date on this Stedman case?
That is 1948.
So we're talking about deeply rooted again. So from 1948 to whenever, abortions were legal before the quickening.
Under the common law. And then in later regulations, abortions were treated as misdemeanors without.
What's the significance of, let's say we agree with you, what's the significance of that to our analysis?
So again, Your Honor, our view is that you can rely on the text and this court's existing precedent to decide this case. To the extent that you look to history, as some have suggested you do, I think the significance of that shows that, in fact, under the common law, abortion was not just, there were different codes in application. It was legal under the common law until the point of quickening. The other thing that I will say, with respect to looking to history altogether, my friends on the other side have said.
It's an interesting point because I feel like when we look at deeply rooted rights, we're not looking at whether it's legal to do something. We're looking at whether it's illegal for government to prevent you from doing it. And to say that abortion was legal under the 1883 Act as interpreted in Stedman is not to say that it is unlawful for the legislature to change that rule. And that's what a deeply rooted right is. A deeply rooted right would be one that the legislature cannot take away. And there's nothing that I hear you saying in this whole analysis of the 1883 Act and Stedman that causes us to think that the legislature can't change that rule.
Well, certainly the common law, the legislature does have the power to change it, which is all the more concerning when defendants have said, essentially you might look to the common law to prevent the kinds of hypothetical statutes that we have posited. In terms of the looking at the history, though, the other point that I do want to focus on is, one, I believe that the state has indicated that there was a respect for one's body to be left alone historically, and that somehow would come through substantive due process or otherwise. But of course, women's bodies are today understood to be included in that. And so looking at historical regulation, did they talk about abortion? Did they talk about birth control? That has to be viewed in the context of a history in which women were left out of decision-making altogether, and discriminatory statutes that affected women's lives and bodies were not just widespread, but seemed ordinary. So I think that, again, we think you can decide this case on the text alone, but to the extent that you look at history, it should not be for the perpetuation of discrimination against women and the history of them being left out. The other point that I do want to make about, I believe there was a focus on the correlation between the point at which cardiac activity can be detected in a pregnancy and the likelihood that that will lead to a live birth. And I do just want to point out that what the state omits in describing that relationship is the 8 months more of pregnancy on which that pregnancy depends on women's bodies to do the work of getting to a live birth. So when women's bodies are that intimately tied to the interest, again, we think that is a per se unreasonable invasion of privacy. I also wanted, in terms of thinking about the framework, sort of how do we think about issues related to...
Can I follow up on that?
Sure.
What if, and I know you said your clients don't perform abortions after a certain time, but let's just talk about rights, the right, not whether or not somebody's going to do it. If the mother has second thoughts during the 7th or 8th month and her body is still doing the work, does she have the right under Article 1, Section 10 to have that pregnancy terminated?
We are not arguing that, Your Honor.
Okay, so you are saying no.
I am saying that is currently illegal in South Carolina.
I'm saying under the Constitution, would she have the right to terminate that pregnancy?
At that point in pregnancy, this court has already held that there is a compelling interest.
So your answer to that question from Planned Parenthood and your clients is no, she does not have the right.
Of course, that is not the case here. Under strict scrutiny, it would depend on what the government showed.
I would like your answer.
Certainly, we think that at that point in pregnancy, there would have to be an exception for the life of the pregnant woman, which I believe the state would concede for her health and life.
Thank you.
In terms of the relationship between abortion and pregnancy and other bodily rights, the other point that I wanted to make is in the context of Singleton itself. As I understood the distinction that the state is drawing, it is that abortion is sort of sui generis in terms of bodily integrity because it involves another person, as they would describe it. Again, this court and SB1 itself does not treat a 6-week embryo as another person. If it did, of course, you wouldn't have a rape exception. After birth, a woman could not kill her child because she had been raped. So SB1 itself distinguishes between a 6-week embryo and a person. But with respect to this idea that pregnancy is somehow different, I would again say in Singleton itself, the court recognized that even where there could be harm to others, there is a sphere of privacy that protects your body from government interference, even in that instance, if it is not in your own best medical interest. And as the evidence here demonstrates, SB1, far from protecting women's health, harms women throughout the state of South Carolina.
How does the state in the act define this potential life? You said something earlier that it's defined at one thing earlier on than it is at a later stage?
So in SB 1, which appears, it starts at page 101 of the joint appendix.
Well, the reason I ask is subsection 6 in the definitional says human fetus or unborn child each means an individual organism of the species Homo sapiens from fertilization until live birth. So the legislature has made a decision that at conception, life begins. Is that not a legislative finding in the definition section of the Act?
Well, they have defined fetus to mean from fertilization on, yes. And I understand their position to be they didn't need to stop at 6 weeks. They could have gone to
and that's where the
fertilization.
2 weeks come in, isn't it? Isn't that where the extra 2 weeks that you talked about with
yes.
Justice Kittredge come in?
That's correct. But I think if you look at what
since we're talking about having determined when life begins, isn't that very subject, that point, the subject of plenty of lawsuits brought by religious organizations throughout the country? I know there's one in Florida. Saying we are forcing our Christian beliefs on the beginning of life on other religions, and they don't believe that.
Yes.
And objecting to the current abortion laws in those states.
Yes, you're right.
I believe there are 5, if my memory serves me correctly.
That may well be. They are certainly pending. I think that, that is consistent with a right to privacy, that it's not just a right to decide what to do with one's body, but to have one's own views about how the course of your life should go. And we would submit that there are few, if any, choices that are as important to the course of women's lives as the decision whether to have an abortion or to give birth. And for that reason, we would urge the court to hold Senate Bill 1 invalid and unconstitutional. The court has no further questions.
Thank you all very much for this very good argument. You brought other things to our attention. Clearly, we've all paid a lot of attention to this matter, as you all have. And actually, we appreciate the civility, the lack of emotion that was displayed throughout this argument. We anticipated that our lobby would be full, our court outside of the front house would be, out front of the courthouse, would be signs and things of that nature, so we forbid people from coming into the building other than you, because we didn't want that distraction from a very serious argument. These kinds of cases causes us a lot of concern, and we put a lot of emphasis on trying to resolve them properly. But our decision will not be based on politics. It will not be based on cultural differences. It will be based purely on what the law, we believe the law says and requires in this instance. Each time that this court has had a case like this, it's taken us quite a bit of time to resolve them. I remember one case, I believe it's Glassrock, that took almost 7 years. And we won't do that to you, of course. But it was because it was such a difficult situation and it had to be reheard. And we don't think that's going to take place. Thank you again. We're now adjourned.